The next case of the day, which is State versus Garcia. And I should note that Justice Frydenberg is recused in this matter, and the court, Judge Arterburn from the Court of Appeals, has joined the court for this argument. Counsel, good morning to you. Mr. Pickens, good morning. And Mr. Smith, good morning to you. Both sides have up to 30 minutes in this particular death penalty case argument. Do either of you have any questions before we begin? Then Mr. Pickens, you may approach and you may proceed.
My name is Jeff Pickens. I work for the Nebraska Commission on Public Advocacy. The commission represents Anthony Garcia in this automatic direct appeal. The commission was appointed to represent Mr. Garcia in March of 2017. Before then, Garcia was represented by some Chicago area lawyers who called themselves Team Mata. Just get this right out. They were a nightmare. Team Mata is a nightmare, and I think that's clear from the record. Team Mata was comprised of Robert Sr., Robert Jr., and Allison Mata. The Matas were retained by Garcia's parents and brother. They were admitted pro hac vici and were required to work with Associated Nebraska lawyers. Before trial, Allison Mata made extrajudicial statements about this case to the media in violation of the court's protective order and also in violation of the rules of professional conduct. And when she did that, all of the associated lawyers withdrew, leaving them without their pro hac vici status. They found new lawyers who were willing to sign on with them and reapplied for pro hac vici status. Robert Sr. and Robert Jr. were readmitted, but Allison was not readmitted.
And what was the reason for that?
Because of the violations. The violation of the protective order and the rules of professional conduct. What she did, they got discovery from another murder case, and there was some DNA testing in that. And I think that there was a mixture of two people, and somehow she managed to argue that it somehow cleared her client, and that she told the media that it exonerated her client and that she expected the prosecutors to call her and say they were going to dismiss the case. Well, when the judge allowed them to have the reports from the other case, I think it's Blanchard is the victim in that case. And that case might be before you now, I can't remember the defendant's name. But when the judge allowed them to have those materials, he issued a protective order and said that they couldn't do exactly what she went out and did. And of course, what she did was also a violation of the rules of professional conduct. One of the associated lawyers that that worked with them is Jeremy Jorgensen. Of course, you know about Jeremy Jorgensen. This court disbarred him in 2019. And I should say this court also disciplined Ms. Mata in January of 2018. But the loss of Allison to Team Mata was huge because from everything that we're able to get from the record, and I want to first admit that I have not read the entire record. It's a monster. It's the biggest record I've ever seen. But from what Robert Jr. Said during hearings, it appears that Allison was the only lawyer who was really prepared to take this case to trial. So when they lost her, they lost the only prepared lawyer they had. And from the mistakes that they made during the trial, it's pretty clear that at least Robert Jr. did not know what he was doing. In October of 2016, a jury found Garcia guilty of 4 counts of first-degree murder, 4 counts of using a deadly weapon, and 1 count of attempted burglary. 2 days later, the same jury found 2 aggravating circumstances existed for 2 of the murder counts, and 3 aggravating circumstances existed for the other 2 murder counts. In March of 2017, the commission was appointed to be co-counsel with Team Mata. Not too much later, Team Mata withdrew, and we took the case over. We represented Mr. Garcia at his mitigation hearing and at the other sentencing determination proceedings before a 3-judge panel in June of 2018. We also represented him at the time of his sentencing hearing in September of 2018 when he received 4 death sentences. From the time we were appointed in March of 2017 through the sentencing hearing in September of 2018, we made many attempts to communicate with Mr. Garcia and never, ever received a response. And I think from the record, the Matas told the judge numerous times that Mr. Garcia stopped talking to them at the time that they filed an interlocutory appeal from the order denying Allison pro act vici status.
Just before you go on, a large part of the defendant's brief on appeal focuses on assignments of ineffective assistance of trial counsel. Just to be very clear about this, the commission is in the position of being partly trial counsel and partly appellate counsel, right?
Yes.
And so consequently, under our post-conviction jurisprudence, you would not have the opportunity to raise matters that occurred after your office came into this case.
That's right.
Not on direct appeal.
And that's one of the reasons why we wanted the Matas out, is so that we could raise ineffective assistance of counsel for the things that they had done, before we were appointed. We did not want to work together as a team because then we wouldn't have been able to raise those issues. So yeah, obviously we can't raise our own ineffectiveness. This appeal was initially assigned to Commission Lawyer Sarah Newell. She drafted the brief that was eventually accepted by this court in December of 2021. After Ms. Newell's employment status with the Commission changed, I reassigned the case to myself. I did not write any part of the appellate brief. As I said, the Bill of Exceptions is a monster. It's the largest Bill of Exceptions I've ever seen. Somewhere in the record, there's a photograph of the Bill of Exceptions on a cart, and physically, it's just huge. And I knew that there was no way I was going to be able to review that entire Bill of Exceptions, so I didn't even make the attempt to do it. And I am relying on Ms. Newell's brief and also Mr. Smith's brief and the issues that I intend to discuss today. The issues that I do want to discuss, though, there's the jurisdiction issue that was raised by Mr. Smith in the Appellee's brief, and then issues regarding the 1B and 1D aggravating circumstances, and then just a couple of the ineffective assistance of counsel issues. And I may fall into saying IAC, abbreviating it, and so I know you'll know what I mean when I do that. The IAC issues, though, involve Allison Mata's extrajudicial statements, and then also the allegation that she and their defense investigator tampered with a key witness, the stripper Cecilia Hoffman. There is obviously an issue regarding competency. I do not intend to raise that today because the most compelling evidence that he was not competent at the trial level is not in this record. I recently filed a motion for new trial in district court raising an issue with his competency and providing the evidence that I think is the compelling evidence that he was not competent when he was in district court. And of course, that's not in the record before you, so I'm not going to discuss that further unless, of course, you want me to. The jurisdiction question. Mr. Smith argued that the court cannot consider the counts for which Mr. Garcia did not receive a death sentence because we did not file a separate notice of appeal. 29-2525 provides, in cases when the punishment is capital, no notice of appeal shall be required. I don't know if it's necessary to look for a definition of cases. I didn't look for a definition, but obviously a criminal case would include all of the counts filed in the case.
Mr. Smith cites a case.
Rust.
Yeah, and I'll confess, I didn't look at that, but what does that tell us?
Well, what Rust says, and here's the pertinent language in Rust. Automatic, and this is a direct quote, automatic review of the death sentence has come to this court on the murder charge under the provisions of sections 29-2525 and 29-2524 RRS 1943. No appeal has been taken on the other 3 counts. The other 3 counts, he shot at some other people. I think he hit 2 of them and injured them. He shot at a 4th person and missed that person. Russ did not assign error with respect to those counts. So there was not an issue before this court about how to interpret the statute and whether a separate notice of appeal is required. To the extent that the court did hold that a separate notice of appeal is required, I think is dicta. It certainly wasn't necessary to resolve the issue. Again,
I beg your pardon, you're making a distinction between assignments of error and a notice of appeal. I hear it.
Because I think this court has done that.
So
in
with
cases.
respect to assignments of error, maybe I'm misunderstanding it. Are there assignments regarding the use and the attempted burglary?
In our case,
Yeah.
well, there's ineffective assistance of counsel that goes.
By way of ineffective
Right,
counsel.
right,
Thank you.
yeah, only through IAC, yeah.
Thank you.
Anyway, as I said, I think that the language "no appeal" has been taken on the other 3 counts. That might mean there's been no assignment of error, because there hasn't been, but I don't think that is a holding. I couldn't find any other case that held that a separate notice of appeal is required. I would ask you to look at State versus Sheets, 360 Nebraska 325 from 2007. And I know you all know the Sheets case. He was convicted of murder and use of a knife to commit a felony, and he was sentenced to death. And then because of a confrontation violation, both convictions were reversed and remanded for a new trial. The case was before this court on a mandatory direct appeal. I did whatever I could through justice, through the appellate court and the trial court, and could not find any separate notice of appeal filed by Sheets.
The Sheets opinion did not talk about it.
Sheets' opinion did not talk about it. That's right. It did say this is an automatic direct appeal, which this court says in every one of the death penalty cases, but it did not address whether there was a separate notice of appeal or whether there needed to be one, but it did reverse the use count. Anyway, I believe the statute is clear. There's no need to do any sort of interpretation, and when it says in death penalty cases, that includes the other cases that were filed with it and where the defendant was found guilty. I want to go to the aggravators next, 1B and 1D, and I think our argument is pretty strong here. For all 4 murders, the state alleged 1B, 1D, and 1E. B is the concealing, D is the especially heinous, atrocious, cruel, or manifest exceptional depravity, and F is the multiple murder aggravator. So in all four of the murders that they alleged those, there were obviously jury instructions on the aggravators. For the 1B, the court told the jury it did not need to be unanimous with respect to whether Garcia was concealing a crime or concealing the identity of a person who committed the crime. The jury instructions did not identify a particular crime that Garcia allegedly tried to conceal. In Sandoval and Lauder, this court said that the murder that the defendant is attempting to conceal has to be something other than the murder itself. And that language should have been in the instruction. That's plain error. It's also ineffective assistance of counsel because the team MATA did not object or propose a correct instruction. The 1D is really easy for this court to decide. The jury was instructed for the especially heinous, atrocious, and cruel prong, they can consider the victim's mental anguish. Of course, in Sandoval, which came down prior to this trial, this court said mental anguish is not a part of aggravator 1D. And then there was the Torres opinion that came down later, where Torres waived jury for aggravated circumstances, and his panel found both prongs of 1D, and the panel included the language about mental anguish. This court was able to say, okay, that prong is bad because of the mental anguish, but there's strong evidence, compelling evidence, whatever, sufficient evidence of the other prong, so the 1D can stand. But in Sandoval, this court said the 1D has to be disregarded because both prongs were alleged, and you can't tell from the jury's verdict how they decided that. So I think it's super easy with respect to this case to throw out all of the 1Ds, disregard all of the 1Ds, as was done in Sandoval. The 1B.
Is there something other than mental anguish to atrocious, the 1D prong?
Yeah, arguably, the victims died, a violent death, but
Their throat slit.
But that's common. That's common in many cases that the victim dies violently, and I think this court has addressed that. But again, the jury instruction and the jury verdict doesn't give you any insight. Both aggravators are alleged. Mental anguish is part of the definition of the especially heinous, atrocious, cruel. Sandoval says you have to disregard it, and I think this court needs to continue to follow that holding and disregard it. I know I have a heck of a lot of time. I'm usually have to stop mid-sentence and sit down. I'm ready to move on from the 1B and 1D unless there's some questions about that. I do want to talk a little bit about ineffective
Disregarded 1D, do we still have 1B and 1E in each of the?
No, we just have, I think you have to disregard 1B, because in 1B, there's not a crime identified, the other crime, and it doesn't include the language this court said that should be in there, in the Sandoval and Lauder case, that it has to be a crime other than the murder itself. I think that there was some language in there about the jury's left to speculate. Now, in Sandoval, it was easy. I mean, obviously, and I represented one of the defendants in the bank case, but that was easy to identify the crime. It was obviously an attempted bank robbery. But it's not so easy in this case to come up with a crime that Garcia would have been trying to conceal, or to conceal the identity of the person who committed the crime. And I think you have to speculate to come up with a crime, and that's the problem. There was one other case that I wanted to discuss for that, and I don't think is discussed in Sandoval or Lauder, but it's the Myers decision, the original Malice case from back in, I think, '94. Myers was convicted of second-degree murder and use of a weapon to commit a felony. And this court reversed both convictions on the use. You reversed because there was no definition of felony. And he said, a typical juror doesn't know what a felony is, and they would be left to speculate. So you have to identify the felony. And I think that holding applies very well in this case with the 1B, that you have to identify the other crime.
Is that aspect of Myers good after this long journey on second-degree murder?
That part is still good. The malice part isn't, because Burleson overruled Myers. Right.
Okay. Thank
Yeah,
you.
but Burleson didn't touch the use part of that.
Thank you.
What about if, for example, in each of the houses where these murders took place, 2 people were murdered? So is there some argument that at least one of the persons murdered on each of those occasions was done to make sure that the surviving individual couldn't tell anyone about the other murder?
So, for example, Shirley Sherman was killed so that she could not identify the person who killed Thomas Hunter.
Or vice versa.
Or vice versa, and the same with the Brumbacks.
Right.
Right, but we're speculating, aren't we, when we say that? And you know, the fact that that the jury didn't find the 1B on the, I don't think they found the 1B on the Shirley Sherman and Thomas Hunter. Let me go back and look at my notes here, but I don't think they found the 1B. No, they did not find the 1B on the Hunter or Sherman murders, only on the Brumbacks. So, I mean, if you wanted to speculate, I think you would speculate that Garcia killed the Brumbacks to conceal the commission of the murders of Thomas Hunter and Shirley Sherman, which were several years later. But, you know, actually, it's just the opposite. Because of the Brumback murders, the police were able to clear the Thomas Hunter and Shirley Sherman murders. They weren't making any kind of progress in that investigation until the Brumbacks were killed. And then they quickly put things together and arrested Mr. Garcia. So, you know, it's sort of the reverse of that. But again, the jury didn't find the 1B on those first two murders.
In regard to speculation, we essentially are talking about what did a collective jury do, and isn't there always some element of speculation in regard to jury decisions?
Well, there doesn't need to be. If you identify the crime that Garcia allegedly attempted to conceal, then there's no need to speculate. You tell them that. You know, when I do trials like this, I ask for that. I ask for an instruction that tells the jury what the crime is. And I always get it, you know, for what that's worth, because it makes sense, you know, for the jury to be told that.
If some jurors thought it was one crime and other jurors thought it was a different crime, would that preclude the finding of the aggravator?
If both of those crimes were identified in the instructions and the jury was told they don't have to be unanimous on you know, on whether it was.
You just have to find one.
You just have to find one, right? They all have to find there's one. They don't have to agree on which it is. And this jury was instructed on that, but they were not instructed on what the crime was. They were instructed. Some of you can find that it was a murder to conceal the commission of a crime, and others may believe it was to conceal the identity of the person who committed the crime. But we don't know what the crime is. We don't know what the crime is with the Brumbacks.
Assume we throw in with you on this argument, what's the resolution of it?
Well, all you have then is the 1E multiple murder aggravator for all four of them, no other aggravators. And I think the case needs to.
You're talking about, however, instructional error, aren't you? So is there a new hearing, a new trial, if you will, on the enhancement?
No, I think you would. Okay, Sandoval, you didn't need to reverse because he had three other solid aggravators. In this case, when you throw out the 1B and the 1D, all you have is 1E. And I don't think that's enough for this court to say, good enough, we can affirm the sentences. I think you need to send it back for resentencing. You know, whether you need to send it back for a new aggravation trial or you need to send it back to have a 3-judge panel do the weighing that's necessary, I'm not certain on that. You know, I suppose I would argue that you need to go back and have another aggravation trial, and the jury needs to be properly instructed. Okay, so the ineffective assistance of counsel for Allison's extrajudicial statement and her witness tampering, obviously those things are deficient performance. Nobody could argue otherwise. And Garcia was prejudiced by those. With regard to the extrajudicial statement, he was prejudiced because he lost the lawyer who was prepared to try the case. And the other members of Team Mata obviously were fairly clueless. I mean, if you look at Mata Sr.'s closing argument in the aggravation trial, where he only went for a few lines, and he told the jury, you've seen a lot of I can't remember the exact language. You see a lot of gore on television, and then I would ask you to consider your religion. That was his closing argument for the aggravating circumstances. So Garcia was prejudiced by not having Allison there because their other lawyers didn't know what they were doing. And then for the witness tampering.
You have other examples of they didn't know what they were doing?
They're all through the ineffective assistance claims in the brief. I think the brief tells this court that after Mr. Garcia was found guilty, at least Robert Sr. and Jeremy Jorgensen went to Tom Riley, the public defender in Douglas County, and said, hey, what's this aggravation trial all about?
So is that incompetence, or is that a sign that they were trying to do a good job?
Well, you go right from the guilt-innocence trial into the aggravation trial, one right after the other with maybe a day in between, a day break in between. You have to be prepared for the aggravation part of the trial when you're doing the guilt-innocence part of the trial. And for them to not even know what an aggravation trial is about until after the guilt-innocence trial, and for them to go to Riley and say, is it because he used a gun? I mean, it shows you how clueless they are. They're going to be educated, to try to be educated, but at that point it's too late. But it shows you that clearly competent counsel doing a death penalty case would know Nebraska's aggravating circumstances. And these lawyers obviously didn't. And unfortunately, with respect to the mental anguish, it appears that Judge Randall didn't know, and he should have known. I mean, he should have read Sandoval, and he was on the Torres panel. So he should have read Torres when it came down. In fact, we filed a motion asking them to, we objected to the panel considering these aggravators, and I'm making the same arguments I'm making today. And Judge Randall distinguished Sandoval by saying, look, in Torres, the Supreme Court said you go to the other prong. If the especially heinous, atrocious, cruel prong is bad because of mental anguish, you can go to the exceptional depravity prong. But the difference is that was a 3-judge panel determination, and they made specific findings on both prongs. So you could disregard one prong and say that the other prong had been met. So the witness tampering, the thing that bothers me the most, I'll confess, I had a difficult time reading our brief. I had a difficult time understanding our brief. But it appears that there's an allegation that Allison's witness tampering is consciousness of guilt or consciousness of a weak defense that was imputed to Mr. Garcia. And I think that was argued in closing by the prosecution. I'm not sure if there was an instruction on that. But we all know about consciousness of guilt, and it's not uncommon for there to be an instruction. But that's when the defendant is tampering with the witness. When the defendant's lawyer is tampering with the witness, and that is imputed to the defendant, that seems so wrong, and clearly that's ineffective assistance of counsel, deficient performance for sure, and he would have been prejudiced by that.
How big a part was that of closing argument for the state?
I know the state argued that. I don't know the closing argument of the state as well as I ought to. I'll confess to that. I know it was argued. And I know to juries, things like that are a big deal. If a defendant tampers with a witness or tampers with evidence, you can see a guilty verdict coming down. I mean, that's just going to happen. So again, I confess that I'm not as familiar with. I'm not familiar with the record. Part of it before the hearings that we did in district court, I read.
So it seems to me that part of your brief argument was after Allison, shall we say, got into trouble and was kicked off Team Mata, then everybody who was left on the team, including local counsel, seemed to be more interested in protecting her reputation and their reputation than in being counsel for Mr. Garcia.
And the brief argues that the court should have seen a conflict of interest and should have addressed that. And the brief also argues that they should have withdrawn from the case. You know, especially after the witness tampering allegations, they should have, all of Team Mata
So
should have dismissed.
what is
or
your
withdrawn.
authority for that, and how would that work in real life?
Well, in real life, the lawyers would file a motion to withdraw, and I think the judge would allow them to withdraw, and then.
But the brief says that there's a duty of the court to investigate that or to question the defendant about this potential conflict of interest.
That's what the brief argues, right.
I think that's the question the chief was trying to get at.
Oh, I'm sorry.
What authority do you have for that?
If there's any authority that's in the brief, I don't know. I don't know. Well, I've used all of my time. Thank you.
Thank you very much.
Thank
Mr. Smith, good morning to you.
Good morning. May it please the court, James D. Smith, Senior Assistant Attorney General appearing for the state of Nebraska, and also referring to Mr. Pickens. I appreciate his work as always. We've worked together. Both of us have done, for example, a joint presentation to the District Judges Association on CLE for post-conviction. So we've worked together. I have great respect for him. I appreciate the difficulty he's had with this case. I did make the comment to him back in the lawyer's room that when I came here, I did a little analogy thinking I feel somewhat like the gecko in the Geico commercial where at the end he says, "I don't know what we were talking about." My problem in preparing for this case was, I would say, was somewhat, I don't know what we're going to talk about today because we have a 7,500-page bill of exceptions. We have a 453-page appellant's brief, and we have 130 assignments of error. I agree with Mr. Pickens' comment that their brief is difficult to read. At times I found it almost impossible to read because it's confusing. It makes references to other parts that are incorporated by reference that couldn't figure out what they were incorporating by reference. And I do acknowledge to the court that when they filed their motion for reconsideration after the court struck their brief a couple times for being over length, I did file a motion. When they did a motion for reconsideration, I did respond in favor of them being allowed to file their brief. And it's a brief that's 9 times as long as what the court rules otherwise allow. The reason I did that, it's a death penalty case. Death penalty cases typically end up in federal court at some point. There would be federal habeas applying the normal rule that they affirm the state's higher court unless its decisions on matter of law are objectively unreasonable. I did not want to be in federal habeas court in which I was going to be dealing with the argument that I was not allowed, the defendant was not allowed to raise all of his assignments of error because the state court's page limit brief cut him off so that he couldn't even talk about things he wanted to talk about. That was my basis for responding that he should be allowed to file his 450 page brief, make all the arguments he wants to make. I did not want to be in federal court saying, gee, the Supreme Court cut me off. I wasn't even procedurally allowed to argue my case. The result, of course, is we now have this, let's say, confusing,
Well, let
lengthy,
me
overly.
try and focus you, if possible. Can you talk to us about the aggravators?
Yeah, and to me, the argument that they've made is essentially comes down to assignments of error 102 through 106. Those are the aggravators, assignments of error. And one of the first comments would just be procedurally default, because they didn't make any objection to the jury instructions. So absent any objection to jury instructions, the question is then, did you not preserve that issue for appeal in the first place? The second thing I would say is Judge Randall did do an order that I would refer the court to read, because after there was a motion after the aggravator hearing for the court to basically not consider some of the aggravators because the court didn't follow the law on aggravators, and it's really a thing talking about the jury instructions. Specifically, I would refer the court on Judge Randall's order. When you look at the transcript starting at page, if I can get it right, there is an order on the defendant's death penalty motions and objections by Judge Randall. It starts at page 238. And if you go specifically to page 251 of the transcript, it goes into the part about the whether it was error to include mental anguish as part of the jury instruction for aggravator 1D. Judge Randall then goes into an analysis and provides his reasoning for why the objection being made at that time was overruled. And essentially what Judge Randall does is rely upon the Torres case. He cites State v. Torres on the, and the fact that the jury did also find, as far as the alternative and the exceptional death depravity prong, and that the sentencing panel also specifically concluded that the evidence that was presented was sufficient, as found by the jury, to prove the alternative prong of exceptional depravity beyond a reasonable doubt.
So is that a non-unanimous jury finding on depravity, or a presumption that it is a unanimous finding on depravity?
All I would say is I would ask the court to read Judge Randall's analysis that I gave you, whether you buy that or don't buy it, but he does rely upon the Torres case as dealing with the error of
Do you have a response?
the mental anguish, including that in the jury instruction.
Do you have a response to Mr. Pickens' argument that Torres is distinguishable?
Frankly, I don't think it is. I mean, the way I read Torres and is cited by Judge Randall, he explains how in this case, that applying Torres it was properly applied, and the aggravator 1D of exceptional depravity was proven beyond a reasonable doubt. And so that's the rationale Judge Randall gave.
Is it correct?
I think he's correct, but I mean, the court's going to have to read and decide for itself, but I think he is correct. The other things I would say...
Can you help us with why it was correct?
What's that?
Can you help us with why it was correct?
Why it's correct is because he relies upon the fact of the sentencing panel's finding of the aggravators that were found by the jury, and that those were all found beyond a reasonable doubt, including the exceptional
Is it all
depravity.
consistent with Sandoval?
What's that?
Is it all consistent with the Sandoval opinion?
As far as Sandoval, essentially what Sandoval says, I'm trying to get the term right, but the mental anguish, Sandoval specifically says we disapprove that being in the instructions, even though it's in the pattern jury instructions. We specifically disapprove of mental anguish being in there in the instructions because that's frankly not in the statute and it should not be part of the jury instructions. And then we have Torres where we get the same problem, and then we got the same problem again, but then Judge Randall says that relying upon Torres found that that was okay because the exceptional depravity, the evidence was proven beyond a reasonable doubt, which the sentencing panel so found. The other thing I would also argue, in addition to the Torres distinction Judge Randall makes, the no objection to the jury instructions is ultimately, as was done in Sandoval, I think it can be concluded as being a matter of harmless error, because the...
How do you have harmless error in a death penalty case?
Well, in Sandoval, you found there was harmless error. And so Sandoval in a death penalty case found that although one of the jury instructions, which was argued was improper on the victim suffering, was an improper instruction, thus tainted that aggravator. The Supreme Court in Sandoval says, even so, that error is harmless, and then looks at...
Because you've got other aggravators, right?
Because you've got other aggravators that were
Not
proven
because of
beyond a
the
reasonable...
depravity prong. I beg your pardon, not because of the depravity prong.
No, it just totally takes that aggravator out, saying that was error for the jury to have been instructed, the instruction was improper.
So
That's the conclusion.
Pickens' argument here today is you've got two aggravators that are bad, and that only leaves you with one aggravator, and that's not enough.
And I don't think that you only have, you do have two aggravators. If you do the harmless error route, you still have two aggravators for the Brumbacks, and frankly, when you look at, and the emphasis of the sentencing panel, the fact that you had these 4 murders committed, and they were committed 5 years apart, just showed that the aggravators that were proven were sufficient.
You've got multiple murders, that's an easy one.
It's multiple murders. You've got multiple murders over a period of
And
5 years.
How do you respond to Mr. Pickens' argument about there needs to be a crime identified that was being concealed?
The argument I would make on that is, first of all, they didn't object to the jury instruction or tender a more specific instruction defining that term. I think it's pretty self-evident that when you have people being murdered after you have break-ins into a home, that there's another crime that's committed. It's not a traffic violation. We're talking about you're breaking into a home, you're killing people, and they did find...
I beg your pardon, and on the Hunter Sherman murders, what's the evidence of breaking in, quote unquote?
I guess the evidence would necessarily, that's a reasonable implication that when you go into a house and kill people and you have a violent struggle, I think that that's just kind of the inference that would be made was, how do you get into the house to do that? He did, and you did have the evidence that he attempted to break in. One of the burglary convictions was for an attempted break-in at one of the other professors' home who wasn't there at the time. And then the fact that he attempted to break in at the one professor's home and then he is not successful, and he goes over to the other home, the assumption that he's politely knocking at the door, I think you've got evidence of another crime, simply because the evidence of the crime for a jury could easily conclude that you committed the crime of killing these people, breaking into their home, killing these people. That, I guess that also gets me to at least the suggestion that I was making in my brief when I essentially kind of said, there's so many assignments of error here. What is the court going to look at, be actually concerned about, or wants a little more than what the parties gave them?
Could you please today address sort of cumulative assignment of error in regard to ineffective assistance of counsel?
Well, historically, what you do on...
Isn't that kind of the elephant in the room in this case?
Not necessarily. I think the cumulative, historically, when you get a cumulative error, you have to find that errors have been proven.
Well, excuse me, I used the word cumulative, and perhaps I didn't mean it in the sense you're responding to it.
Okay.
There are a number of more specific allegations about incompetency, or excuse me, ineffective assistance of counsel here. And if you could address them, that would be very helpful to the court.
My problem I'm having is we've got 60-some assignments of error on ineffective assistance of counsel.
Are there any we can reach on this record? Which of the 60 or so assignments of error pertaining to ineffective assistance of counsel can we reach on this record? And then let's talk about those.
That's a pretty difficult question to answer during an oral argument when I've got 60 of them, and then just go through. Frankly, I think that would be something that I would suggest supplemental briefing is going to be more helpful than saying assignment of error 12, 13, 18.
We
these
don't
specific
normally
assignments.
do supplemental briefing after oral arguments, unless it's an issue the court has brought up itself.
Well, I've had cases where after the oral argument, the court does ask for supplemental briefing because the nature of the case or issues the court thinks supplemental briefing would help. I would think this is such a case. It's a death penalty case. It's a voluminous record. It's a confusing, very extensive brief. And issues such as, are there assignments of error on ineffective assistance of counsel that under our jurisprudence we can address at this time and thus take them off the table? That's also necessarily going to involve reviewing a 7,500-page bill of exceptions, which opposing counsels even acknowledge he hasn't read. All of it I have. And I was lucky enough that the court reporter honored my request when I knew this case was coming way back when. Can I get an advance copy of the bill of exceptions in a PDF form, which then I got and I've had time to read. The problem that gets very apparent from that is if you start going through that, addressing a specific assignment of error that appears to be of some concern, you really have to focus more than I think the focus has been.
One of the arguments, it seemed to me, to be in the defendant's brief was that after Ms. Mata was taken off Team Mata, and I believe it was repeated here in the courtroom today, she was the person who knew what was going on, and the other members of the team did not know what was going on, and that the team that remained spent most of their time trying to protect Ms. Mata's reputation and their reputation and not in defending Mr. Garcia, and that at some point in time Mr. Garcia got so frustrated with his counsel that he refused to talk to them thereafter.
I don't think the record's sufficiently clear to say that's actually what was going on with the defense team, or that that was her role, or that was the effect of removing her, or that you couldn't have asked for a continuance if you were going to find out that removing her meant that we were now short-staffed on dealing with. I think all of those types of things are not sufficient in this record to reach that conclusion one way or another. I would say the competency order that Judge Randall eventually entered, he entered an order on competency on March 28th, 2017, in which he agrees with Dr. Hartman and also Judge Randall's observations of the defendant was essentially malingering. He seemed to be able to respond when he wanted to, and so he had a concern that we have a defendant who appears to be malingering, and then the defendant, in various points through the record, where the judge is concluding that is the defendant who's electing not to communicate with his counsel, which, if he doesn't want to communicate with him, as far as Judge Randall's concerned, that's his choice. But I don't think that turns into ineffective assistance of counsel. That turns into a defendant who decided he didn't want to cooperate with his attorneys, but he didn't want to represent himself either.
Is there enough?
I don't think that's ineffective assistance of counsel.
Is there enough in our record for us to find an actual conflict, that Team Mata had an actual conflict and therefore kind of jump to the presumed prejudice discussion?
I don't think so.
Why not?
There's not enough in the record to explain what's going on with counsel. We don't have any evidence on strategic decisions made by counsel, why counsel is doing some things, why they aren't doing other things. The record just is not sufficient to just say we can reach that conclusion from reading this. You might have an impression, but that's not sufficient to reach a conclusion of a conflict of interest that prejudiced the defendant. The fact that someone is removed from the case and you still have attorneys, a team of lawyers representing the defendant, you've got the commission jumping in at some point in time. They're also appointed. We have Judge Randall lecturing the attorneys that you all have to cooperate and work together on this, which they seem to acknowledge.
Is your argument ultimately that this needs to be, the can needs to be kicked down the road to post-conviction hearings on all this?
I think probably all of us is going to end up there, except I think Judge Stacy's very good question is, of all of these assignments of error, are there some that we could decide now, the record's sufficient to decide them now, and if so, which ones? I don't think.
Can you help us with that?
I think I can help you very much. I would like to help you on a supplemental brief if the court wants that specific question answered. Otherwise, a lot of this is going to be kicking the can down the road. They've made the argument that the Supreme Court's procedural default rule should be overruled. And I think the Abdullah case does a very good job of explaining why Nebraska Supreme Court has not adopted the federal Massaro decision. And for judicial efficiency, I think that makes a lot of sense. And I'll frankly acknowledge, I've told district judges, if you get this voluminous post-conviction motion, if you just simply deny it, defendant appeals, it goes up to the Supreme Court, and the Supreme Court will then tell you what, if any, claims on which you have to have an evidentiary hearing. The appellate process on a direct appeal could be so apparent on some assignments of error that you can look through a 7,500-page bill of exceptions and say, from looking at this here, we can see that assignment of error 22 on ineffective assistance of counsel has no merit. But the problem is just we've got a brief that's 9 times as large as we've ever had. We've got an extensive record, and I think it's a rare case, but it's a rare case in which I think, and it's a death penalty case, and I think supplemental briefing would be helpful, but it may be more helpful if we know issues that the court wants us to more specifically address with helpful annotations to the record as to where we can find these things, and also...
You want us to give references to you?
No, we would do that. We would do that. I think that's helpful to the court.
It sounds to me like you're seeking a supplemental briefing order that says, please identify the assignments of ineffective assistance of counsel that can be reached on the existing record and the proper disposition
Would be
thereof.
helpful.
That's what you're seeking.
Yeah.
All right.
I think it would be helpful to us. I think it would be helpful to the court.
I want to ask you about the jurisdictional argument regarding the non-capital
Yeah.
convictions. Your opponent argues that Rust is distinguishable. I'll take it a step further. Is Rust simply wrong
It might.
as a matter of statutory interpretation, particularly looking at Section 29-2525?
It may be. The reason I put that in the brief was the Rust case is there, the language is there. If the case is wrong, then the issue is, should the court issue an opinion just saying, we overrule that? I jeopardized everything. I couldn't find any subsequent case that addressed that issue. It may very well be wrong under the idea that the statute, what the statute says, you get an automatic direct appeal
In a case.
in a capital case.
Yeah.
Well, I'd have to read the statute again. I'm not sure if it uses the word case or whatever used.
Well,
But
the opening phrase, I'll give you the help. In cases when the punishment is capital,
Yeah.
no notice of appeal shall be required.
Yeah.
And then blah, blah, blah.
Yeah, and my thought was, if that's wrong, it should be brought to the court's attention, and if the court then wants to overrule that, it should, and then nobody's going to be relying on that anymore. I did put that same jurisdictional statement in the Trail case, which was recently affirmed, and there wasn't any comment in the opinion about it at all. But I did find it troubling. I always find it troubling when you have a case out there, there's a specific quote, and the court has not yet overruled it, maybe should. Because what I tend to see on these death penalty cases is the clerk just sends up the appeal. It's a mandatory direct appeal. There aren't any notices of appeal on collateral convictions, but we still have the language here in which, in the Rust case, to me, when I read that case, they didn't say no assignments of error. They said no appeal. And that's different than saying no assignments of error made. It says no appeal was taken, and so thus they don't address any of the other counts. Right or wrong, whatever. I have no problem if the court overrules it. If the court agrees with it, fine.
Or just simply saying, that wasn't what we meant.
That's fine.
Yeah.
Distinguish it. I know the court doesn't like to overrule cases, but if it wants to distinguish them so nobody's,
Relying on that.
yeah, in the future. And I think in a death penalty case, that's, jurisdiction's important. And it's, to me, it's always, should be the first issue the court looks at. I've always done that I look at the jurisdictional statement, take that serious. And because I know the court, sua sponte, can say no jurisdiction, and it's done that a lot, so.
Thank you.
So, obviously, I've lived with this case a lot longer than the court has. It's voluminous, it's overwhelming. The briefing is such that I don't know how helpful it has been. I think it could be more helpful if the court would ask for supplemental briefing upon seeing the issues, because I mean, if we're talking about assignments of error 102 to 106, that's buried pretty deep in a brief. And I can only remember my arguments. One time I remember there were like 30-some assignments
I
of error. and I got-
want to ask you a little bit about the equity of that, since if we ask you to, for example, specifically point out the issues of ineffective assistance of counsel that can be disposed of on direct appeal or not, are we to ask the same thing of the defendant in this case? Haven't they already done that?
I think it's how you phrase it, but I think it is fair for the court to ask supplemental briefing on what assignments of error, because they're saying some assignments of error cannot be disposed of on direct appeal. Some can. I think it's helpful to know which assignments of error actually can be disposed of on direct appeal, which necessarily means the ones that can't be disposed of on direct appeal are still there.
I probably should have asked the question of your opponent, but I'm going to ask it of you in case he gets a chance to say. Is another elephant in the room the appellant's brief in this case and the difficulties that it poses, as both parties have talked about? Is this a case where replacement briefs would actually be useful?
I do think that would be helpful. The problem is the court going to impose a page limit on replacement briefs?
Of course, they're now word limits, so.
Or word limit, yeah, that's true. Is the court going to say not to exceed, whatever? Fine, I think that's helpful, but yeah, if you want to talk elephant in the room, that's almost probably one of the biggest elephants with the entire case.
Let me just follow up on that thought, if I may, and perhaps we all agree not all assignments of error are created equal. But in the direct appeal context, is there not an obligation to raise, I want to say, all of the issues for which there may be merit by an appellant in the capital case?
Well, there's an obligation to raise all issues. Whether or not they have merit or not, I guess is, they should, but they don't. And that gets back to what was my concern. This case ends up in federal court on federal habeas. I do not want to have the argument that the Supreme Court of Nebraska put a page or a word limit on me that effectively meant I wasn't allowed to make these arguments that I think are meritorious. I think that's a legitimate concern. Federal courts are required to uphold the decisions of a state's highest court as long as they're not objectively unreasonable, which would necessarily imply that defendants, especially in a death penalty
So
case,
are you
were
making
given
an
the
argument
opportunity.
that there should be supplemental briefs, but we shouldn't put any limit on them?
If we got well, if the court, I mean, the court's got the briefs, it's got the 160-some assignments of error. I know this court, quality of its work, I would expect the court itself should be able to identify out of those 100-and-some assignments of error which ones it believes would be helpful to have more briefing, more focused briefing, general issues it might want to be better addressed. And it's an unusual case. The fact that it's a death penalty makes it another unusual case. I know when there's going to be post-conviction, most likely, the defendant's going to be entitled to have counsel appointed in post-conviction because this court has reversed a case, I think it was Galindo, where the defendant was denied counsel in a death penalty case at post-conviction. It was reversed with directions to appoint counsel. So he's going to have counsel at post-conviction. So I think a lot of this stuff might be able to be eliminated by having more focused briefing on which assignments of error can be disposed of or not disposed of on the record that we have that has annotations for the court's benefit as to why that is so. We don't have that.
Why didn't it happen the first time?
I guess I go back to the length of the record, the confusing nature of the brief, the difficulty actually reading that brief, figuring out what are the assignments of error that are actually significant enough that need to be thoroughly addressed. And as I said before, when you're up here making your biggest pitches on assignments of error 102 to 106, it is somewhat difficult to say, gee, until now I didn't. Yeah. For me, I'm used to, if you're going to do an assignment of error, your best one should be 1, second best 2. It shouldn't be 102, it shouldn't be 103, 104, 106, which doesn't really give one much help to figure out what are we really looking at here seriously that may have some merit. So, like I said, I worked with the case a long time. I eventually kind of reached the point that I did somewhat throw my hands up in the air and conclude that this is a unique case. It's a very extensive case, and I think it's a case the court wants to get right. And to get it right, it probably is helpful if we do supplemental briefing on assignments of error, because we already know from the opposing counsel's oral argument, 102 through 106 appeared to be significant. It's on the aggravators. So,
Thank you very much.
thank you.
Do we have time for rebuttal?
No, Your Honor.
Mr. Pickens, I do want to hear from you, however, on the issue of supplemental briefing.
And replacement briefing.
And replacement briefing.
Right. I guess I want to start off by quoting Justice Castle from a seminar I attended. I think a lot of the problems in the appellant brief is due to the tyranny of page limits. I really, when you look at the assignments of error and we're incorporating this prior one and all that language that makes it so difficult, even with the extensive pages that you allowed, there were still problems. I don't think the answer is an 800-page brief.
I guess the candid question that I would submit to you, because you're now in the place of your former colleague, and we all have respect for your former colleague, and I don't ask the question to disparage her in any way, but if you had your druthers, would you rather restart with a different appellant's brief?
Well, I'm down one lawyer, and I can't hire another lawyer until the legislature adequately funds our office. We are declining appointments in every case except murder cases. So if you want me to write a brief to start over again, it's going to take me a long time because I have other things to do, and of course my lawyers are all extremely busy, and I intend to retire next summer. And Mr. Smith made a comment to me before we came in here that briefs like these could cause a lawyer to retire. And so I guess I'm not going to argue against replacement briefs, but it will be difficult for our office to do one. It will take us a significant amount of time. It's not something we could crank out in 2 or 3 months. Is that all you wanted me to address, Chief Justice?
I think.
Okay, thank you.
Well, just with respect to supplemental briefing, even if we don't do replacement briefing, and we do ask for supplemental briefing. How should such a supplemental briefing order be articulated that you think would be helpful to this court?
I don't know. When the Chief Justice asked a question about supplemental briefs, I don't have experience with that as Mr. Smith might, but I have seen other cases where that's been done, and it seems to me it is typically done when the United States Supreme Court comes down with a decision that affects the case after the case has been argued. That's when I've seen it. Justice Stacey has a good idea, I suppose, about, with the IAC issues, which can be addressed now. But I think Ms. Newell did that in her brief. I think that's already been done. I don't know if Mr. Smith agrees with that. I don't really have a recommendation. We obviously will do whatever you want us to do.
Thank you.
Thank you.
Thank you very much, counsel. That concludes arguments in State versus Garcia. And with that, you are excused, and the court is adjourned for the day. Thank you.